Hello, I'm Max Davis. I'm a barrister from Thilly Park Place in Cardiff, and I specialise in financial remedies. I also sit as Deputy District Judge of the Financial Remedies Court. And this is part of a series of short videos we're making at Thilly Park Place about private FDRs. If you practice in the field, you'll be aware of growing support of the use of private FDRs over the last few years. Here I'm going to talk about some of the support for private FDRs from the judiciary, quickly in the first half, and then I'm going to deal with how that informs the way that private FDRs fit into the court process. Now, barristers have offered private FDRs for many years, but recently the courts have begun to add real support to their use. In 2017, when the revised standard orders were published by the Financial Remedies Working Group, they included for the first time reference to adjournment at the first appointment for a private FDR. That's at paragraph 81 of that pro forma 1.1. The following year, in 2018, the then President, Lord Justice Mumby, on the day of his retirement, published a President's circular entitled the Financial Remedies Court Pilot Phase 2. In that, he said, "I hope the lead and other judges will take the opportunity to develop and encourage the use of private FDRs locally." And he then gave a number of reasons supporting their use. You all know how that hope has manifested itself in the judiciary in your area. Then, in the foreword to a recent publication called Private Financial Dispute Resolutions, a Short Guide, published by Class Publishing in 2018, the current president of the Family Division, Sir Andrew McFarlane, stated, "I stand as one with my predecessor, Sir James Mumby, in hoping that all family judges will take the opportunity to develop and encourage the use of private FDRs." Then we had some guidance within the last 6 months, so very recently, in the form of the Financial Remedies Court's Good Practice Protocol from November 2019. And paragraph 10 of that protocol deals specifically with the conduct of private FDRs. Paragraph 10 was drafted with input from both the FLBA and resolution, and it sets out some of the considerations there. Some of those considerations are what I'm going to be talking about in a moment. So that's all the support that private FDRs had prior to the current COVID-19 crisis. Then you'll remember that there was guidance provided back in mid-March when it was first clear that there was going to be a lockdown. Firstly, from the National Lead Judge, Mr. Justice Mostyn, who set out guidance very early, actually on the 17th of March, identifying that parties should be encouraged to have FDRs privately and that such private FDRs should be done remotely. There's no doubt that can be done easily and at the convenience of all parties. And then 2 days after that guidance, we had the President's guidance, which was an all-encompassing guidance for the Family Division. But in that, the earlier guidance from Mostyn was endorsed and appended to that guidance. And at the time, there was all sorts of amount of guidance being provided in life in all areas. We were being given guidance as to how to wash our hands, how to cope with the day-to-day challenges of social distancing. So what is the relationship of the private FDR with the court process? Well, it's set out to some extent in this guidance that we've had, and there are some points that can be construed from the various guidance. So firstly, at the first appointment, if you consider and the parties consider and the court agrees that the case is appropriate for a private FDR and that settlement can be achieved in the current circumstances, then the intention to refer the matter to a private FDR should be noted in the preamble. Ideally, parties should identify the date for the private FDR, and there's no reason why, if it can't be agreed, the identity and location of the FDR can also be included in the draft order. And then, and this is important, a directions hearing is then listed after that date, or if there's not a date in mind, after a window for the private FDR, for a directions hearing. And in fact, paragraph 10 of the protocol refers to that specifically. Now, if the private FDR is successful, then obviously a consent order can be filed with the court. D81 is probably not being necessary because Forms E will be on the file. If it's not successful, then what are the parties to do? Well, paragraph 10 of the Good Practice Protocol provides some input into that. Firstly, they should inform the court that a thorough FDR exercise has taken place and provide a written explanation of what's happened to the FRC judge who heard the first appointment, so that that judge can be satisfied that such has taken place. Secondly, unless the FRC judge asks for an explanation of the without prejudice positions, they shouldn't be given in the first instance, because obviously that would necessarily prejudice that judge or any judge reading them from dealing with any further substantive hearings in the case. The parties should set out and describe the nature of the private FDR, the tribunal, the evaluator is preferred to the word judge, the time spent in engagement in the private FDR, and assurances that offers were made on each side and an indication given. The court should then not require a court-based FDR. And why would it in the current circumstances, not only with the pressure on work currently with judges widely working remotely, but also for, I'm afraid, many months, if not years to come, with the backlog that will need to be cleared. Then there is the directions hearing, which is listed at the first appointment, and that can then be heard remotely in order to list the matter through to trial. It's quite obvious that both practitioners and the courts need to identify cases that are going to be suitable for FDR as soon as possible, refer them to private FDRs, which can be heard remotely, and alleviate that backlog of cases which we're all going to have to face at some stage in the coming months. Thank you.